entered a plea of guilty to driving while intoxicated with a child under 15 years old. There was a punishment. It was sentenced, and it has been less than 30 days since then. And I've received a motion for new trial that has been filed by Mr. Parker that states that Ms. Malfino, you're in agreement with this motion because there was a mistake in y'all's calculation of time credit. Is that correct?
Correct. The purpose of this, judge, is we're trying to get him out of here because he pled out on his case, the underlying case that caused the motion in Harris County, and was sentenced to probation over there. And one of the conditions of probation, it's not safety, but it's an in-house treatment facility over there. And so we thought he had more credit because he had been arrested in October, but apparently the motion wasn't filed. And it wasn't filed till like January, so he didn't have credit for that time that he was actually in custody.
He may lose that bed over there based on that
Okay.
probation. So ours was a state jail felony, which you allowed us to offer a 1244 on. He just didn't have as much credit as it appeared he did based on the offense date. There was not an appropriate
Right.
rule or something.
We've got an agreement, if the court allows this, we got an agreement for a little less time, basically.
I'm fine with that. I guess I'm wondering.
And I just kind of did that off the top of my head, a motion for new trial with the nunk of the judgment and then resentencing, if that would.
Well, we would have to do the whole, if the motion, which is fine, we'll just have to go through the motion to revoke again.
Right.
Get pleas on that.
That's fine.
Is there, what about just a motion to reconsider? Can we just change?
I
think
can
I
do a
need to-
motion, an oral motion to reconsider
I
sentencing.
don't want anything orally done
Okay.
because it won't make sense in the file
Yeah.
that I just changed it.
Yeah.
Let's just do it this way. I'll grant it, the motion for new trial, and then you guys can get the paperwork done and we'll take that plea up in just a few minutes.
It would be okay with the court for us to just proceed on count one, which was that new offense in
Sure,
Harris County.
I'm fine with that. We don't need to, the less we have to go through and read, the better.
We got it done, she's got it.
Gee, you're done, huh?
What?
What are we doing on yours? Oh, y'all are doing paperwork? Is it done? Here it is. Michael Davis. So, do I need to take the original motion to revoke and do it again?
I don't care about this one. Hey,
Or take the, you know what I mean? Since I rejected the offer,
that's the
it's like a motion for new trial, it's like we're starting over.
Sure don't act like it.
Yeah, maybe. I know that he's doing all of this with.
I can move it all over. But the problem is, like, I didn't have it on this morning, and the first thing I do is go pick up a weed eater. I'm like, oh, you can't do that.
Let me, I think that's probably best. And then maybe if there's a way for y'all to scan it in, that way you can name, when y'all scan it, you can name it second some.
Yeah.
That's not this. Okay, back on the record in cause number 19-32496. And sir, again, you're Michael Davis. And Mr. Parker, will your client waive the formal reading of the motion?
You will, Your Honor.
And it's my understanding we're going to go on count one only, correct? Mr. Davis, I have a motion to revoke your community supervision. Shows that you were placed on probation March 3rd of 2021 for the offense of driving while intoxicated with a child under 15. And that was a 2-year term in the state jail that was probated for 4 years. Is that correct?
Yes, sir.
It alleges in count one that you committed the offense of driving while intoxicated third or more February 5th of 2025 in Harris County, Texas. And is that true or not true?
True.
Did you enter your plea of true to count one freely and voluntarily?
Yes, sir.
and because you actually did what it says you did. I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
I think so, yes, ma'am.
And, well, do you understand that if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Davis is not competent?
No, Your Honor.
And so, Mr. Davis, I just want to make sure that you understand that if I follow the agreement, it's for a 120-day term in the county jail under Section 1244 of the Penal Code, which means you have the state jail felony conviction, but you will be able to serve any time in the county jail. You will be given credit on that for any time that either we had a hold on you or you were in our county jail. Is that your understanding?
Yes, ma'am.
All right, then I'm going to find that you entered your plea of true to count 1 freely and voluntarily. Find that count true, find sufficient evidence to revoke your probation, and at this time, revoke your probation. Reassess your punishment in accordance with your agreement to a term of 120 days in the Jefferson County Jail under Section 1244 of the Penal Code. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. I've also handed you that written admonishment regarding your ineligibility to possess a firearm or ammunition. We went over that a few weeks ago. I'm not going to read it again. You understand that you are not eligible to possess a firearm in Texas. All right, good luck to you, sir. You can go back with the bailiff.
Thank you, Judge.
Martin.
Let's take care of Caddy.
Mr. Caddy is habitual status,
Uh-huh.
so we need a little bit more time so I can make sure I go over all discovery and
Okay.
see what he wants to do.
Okay, we'll do one more recess to give you some time to get that
Yes,
taken
ma'am.
care of. And then Daniel Martin. Do we not need him?
Judge, he's here to speak with Mr. Robbins.
Okay, all right, I'll just do a normal reset on Daniel Martin. Make sure they don't take him back, though. On Daniel Martin, hold him, please. And then Junius Pugh,
That's a plea.
We can just proceed on counts 1 through 3.
I can't hear you.
We can just proceed on counts 1 through 3 if you want.
Okay,
No offenses.
Yeah, he's been sentenced already in Harris County.
Okay.
So he's serving time.
let me get it pulled up. So is this motion from 2020?
Yeah, he's been in
been
custody
in
since
custody.
then.
Oh, gotcha. Good morning, sir. Are you Junius Pugh?
Yes, ma'am.
And will your client waive the formal reading of the motion?
He will, Your Honor.
My computer's going slow. All right, Mr. Pugh, in cause number 15-21944, I have a motion to revoke your unadjudicated probation. And will he waive the formal reading of that
He
motion?
will, Your Honor.
It shows that you were placed on probation June 22nd of 2015 for the offense of retaliation, and that was a 5-year deferred probation that's been extended. Is that correct? It alleges in count 1 that you committed the new offense of robbery, threats, November 27th of 2020 in Harris County, Texas, and is that true or not true? Count 2 alleges that you committed the offense of assault family violence on November 27th of 2020 in Harris County, Texas, and is that true or not true? And then finally, count 3 alleges that you committed the offense of robbery December 5th of 2020 in Harris County, Texas, and is that true or not true? Did you enter, and the state abandons 4, 5, and 6, correct?
That's correct.
Did you enter your pleas of true to counts 1, 2, and 3 freely and voluntarily? And did you plead true to those counts because you actually did what they say? I have here on the computer some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Ms. Holmes? And do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Pugh's not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. Find sufficient evidence at this time to find you guilty and find you guilty of the third-degree felony offense of retaliation. Sentence you in accordance with your agreement for a term of 3 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I am handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Ms. Holmes. All right, good luck to you, sir. You can go back with the bailiff. Yes, ma'am. Give just a second, please. Yes. Good morning, sir. Are you Preston Fontanet? And Mr. Fontanet is charged with unlawful possession of a firearm by a felon, and looks like in March failed a drug test in court, tested positive for cocaine in court, and so I revoked his bond.
He then pled guilty, Your Honor, and the plea was not accepted based on statements he made in his PSI. We had that sentencing hearing a few weeks ago.
Okay. Mr. LeBlanc has filed a motion asking that I set bond, and I made made the finding that it was appropriate at that time to have no bond. Is that correct, I guess? There's no bond set at all? Hold on. You wrote it on the sticky, but I just don't know why. I'm trying to go back and see why I would.
I think, I believe that it is in the bond. I think I even went back and looked in my docket, and that's what you said.
Okay, I'm sure I had a reason. All right, so, Mr. Fontanet, do you intend to ask your client any questions?
Judge, if I may, could we set this aside and possibly, we'd like to readdress the offer and accepting the state's offer, and my client would like to address the court if possible. That's really where we're headed, if the court will permit.
Well, here's what I would like to do, because I've obviously slept since then and don't recall everything. However, I do remember some things. I am going to want some time to go back and see exactly what happened in court that day for me to do what I did.
It's a one line, Your Honor. His version of events was, I quote, "I didn't really commit a crime at all. I didn't do anything."
Right. I just wonder if there was something else said or done as to why I did a no bond. There was.
I don't have a note on that, Judge, so I can't answer that.
Just handed me this, I'm sorry.
I don't know the judge.
I don't know if that helps.
I still think that. Well, I mean, it's been rejected, so there's no going back, and y'all would have to redo paperwork and all of that kind of stuff. But before we do that, I really do want to go back and see at the last court hearing or two, and I'm not going to be able to do that obviously this morning, so I can reset it just 1 week to next week. And between now and then, I'll get Ms. Tanner to pull up so that I can go through, figure out exactly what happened while we were here on the record, and then I will let y'all know if I feel like I would I mean, there was also the fact that he just got revoked on 2 different cases
That's true, Your Honor. He does have 2 revocations on his other felonies.
and got 1 probation while he was on probation for the other and then messed that up. So I'm not real sure that that's part of what my notes are here anyway. So let me reset it for a week. Let me get caught up on what I can't remember on why I no bonded it. I'm sure I made some finding on that so that I can see where I was, and then I'm not going to let's not talk about the bond today until we know what we're going to do on that. I'll reset it for 1 week.
Thank you.
So we'll be
Now,
back next
if
Tuesday.
the court would like to do it sooner, I'll be available.
Yeah, I don't think we can do it this week, but I'll get it, we'll take care of it next Tuesday. Good morning. Are you Nakia Latrell Jackson?
Yes, ma'am.
And Ms. Jackson, in cause number 19-32344, you were here before. You're on a 10-year deferred probation for burglary of a habitation. And there was a motion to revoke your probation filed. You came to court, pled true to counts 1 through 9 in that motion. And I've received an updated pre-sentence report. Has everyone had an opportunity to review that report?
We have, yeah.
Yes, Your Honor, we have.
Are there any additions or corrections to the report?
Not from the defense.
No, Your Honor.
All right, Mr. Rojas, and there was no agreement, correct?
That is correct. Yes.
All right,
I think we did not reach an agreement.
Right.
okay.
Yeah, Judge, we went over the PSI at the jail, and I discussed her the possibility with Ms. Jackson about the possibility that the previous recommendation had she would have been, at one point, would have been safe P. She tells me that she doesn't feel that she needs safe P. She thinks that all the tools she needs, she got from ISF when she was at ISF. Her problem, she thinks, is that when she was released from ISF, she just was homeless, didn't have any place to go. And that one thing led to another. She didn't have a home, didn't have a phone, didn't have transportation. And that's one of the reasons, or the reason that she couldn't get into the drop program, which led one of the reasons we're here today. If you read her comments in the PSI, she's asking for another chance, and she truly wants another chance. She tells me that if she's given another chance, she does have a job for her on the outside. She's waiting. She has a job waiting for her at Waffle House. She has 2 possibilities of where she could be living. She could either go with her aunt who lives in Orange, I believe, who's a school teacher in Orange, or the manager, her manager at Waffle House would let her live with them in Port Arthur. And that's what she's asking me to do, Judge. I know that it's hard because of the comments on the PSI where she didn't report, didn't go to the drop program, just kind of disappeared for a while. But she's asking me for another chance, and I think she has some comments to make whenever the court feels it's appropriate.
What's the status of the theft case and the failure to ID?
Those are pending misdemeanors, Your Honor.
Okay,
I'll probably dismiss them depending on how
okay. Mr. Nichols?
Judge, I want to make the court aware of the full history on this case. Ms. Jackson was originally on probation before this court on a 2012 burglary. She then committed this offense, and we had a hearing. I think it was a 7-year cap originally, and she was continued on probation. Since that time, she's been ordered to and successfully completed ISF, but then continued to violate probation and was ordered. Would have been sent to safety last year, but then she absconded and stopped reporting. Along with that, I don't think she's done anything really since September of 24, and that's all the violations that are alleged for this motion. So she has been given every opportunity, every service that we offer to try to help her, and she keeps coming back to using and not participating in probation. So I think revocation is in order, Judge.
Thank you, Mr. Nichols. All right. Ms. Jackson, do you want to say something?
Yes, ma'am. Thank you for letting me appear and be able to speak on my own behalf today. Judge, whenever I did appear before you last time, I was on 2 10-year probations. I did complete one of them. And since then, I have been to ISF. I learned a lot from ISF. When I was released from ISF, I didn't have a stable place to live. I didn't have anything. And like he did say, I was off my meds. I wasn't in any kind of predicament to take care of myself. Since then, God has blessed me to be reconnected back with my family. I have a stable family support group now, and I can stay back on my meds. If you would give me another chance, I even said I tried the JCDI program or something, maybe out to become a productive member of society. If you allow me to just try, maybe I'll double my fees on probation, do all my classes, try to get off early. I would like to try to get off early, go back to school, be a productive role model for my grandbabies. I learned so much in ISF. I didn't get a chance to if you just give me a chance to prove it to you.
I feel like I've heard that before.
I never took
You've been on, hang on.
I'm sorry.
You've been on probation since 2012.
Yes, ma'am.
You didn't successfully complete a probation. We just let you get off of that one because you got on another one. Because while you were on a probation for a burglary of a habitation, you got another burglary of a habitation. And you were lucky at that point because you got another chance. And so here's the thing. You say you've learned from ISF.
I really did.
But, and maybe you did, but if you're gonna stay on, the fact that I'm even considering this, so you don't think you need to go to SafeP?
No, ma'am, if you just please, I have a job.
You're not getting out today. You're going to prison or you're going to SafeP. It's that simple. You're not gonna keep doing things that you're not, hang on.
Okay, yes.
You're
ma'am.
not gonna keep messing up and then get rewarded for that bad behavior. Does that make sense?
Yes, ma'am.
So you've been given opportunities, both tracks of ISF. You were placed on a special caseload to help you with any issues you were having, and you didn't do what they were asking you to do. So it's either special needs SafeP. Special needs SafeP is gonna take care of hopefully some of the mental health issues as well, correct? Ma'am?
I don't know about, safety.
Well, so there's a SafeP program. There's two different ones. There's your regular SafeP that's primarily just obviously drug treatment. Then there's a special needs SafeP that also takes into consideration any mental health issues and help for somebody who might need some help with regard to that, which is clearly, it looks like what you would qualify for because you have refused to go get any of the mental health treatment that has been offered and handed to you while you're on probation. So what I'm going to do today, Ms. Jackson, and I'm probably going to look, hopefully I won't, but if I look back on this again, I'm telling you now, if you're back in here, I'm going to wonder why I did what I did today. And if I have to wonder why I did something, it's usually not good. You could go to prison today for up to 20 years. Up to 20 years today, I could send you to prison. And if you're back in here and you don't take advantage of what you're given today, then you're going to be looking at that entire range of punishment, and it's probably not going to be on the low end. Do you understand? I'm going to find that you entered your pleas of true to counts 1 through 9 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty. However, I'm going to continue you on probation. I'm going to order that you enter and successfully complete the special needs SafeP track. You'll get hopefully more tools and all the tools that you need to get out and complete this probation. You will be on 0 tolerance. That means you cannot miss one appointment. When you get out of safe P, then if the probation department thinks that JCDI is appropriate for aftercare or the drop program, you miss one appointment, you miss one testing, then you're gonna be right back in here with a motion to revoke. This is it, no mess ups, not even a single one. Do you understand? That's what 0 tolerance means. All right, I'm going to hand you the trial court certification. This was not an agreement. There's some rights to appeal. You can talk to Mr. Rojas about that. All right, good luck to you, ma'am. See, Mr. Rojas, you have Gabriel Smith.
Maybe.
Is this his? All right, you're Gabriel Smith. And so Ms. Smith previously, well, first of all, this is cause number 23, DCCR 1034. Ms. Smith, you're charged with the second-degree felony offense of robbery. There was an agreement reached by you guys at some point for a cap of 5 years in prison. I rejected that after seeing the pre-sentence report and Louisiana history. And so this is just a status hearing. What is the status?
And Judge, I'm sorry to interrupt, we were all kind of anticipating that. There was so much Louisiana history that was hard to detail from NCIC, TCIC that I had, and so we were really all in agreement that that was not an appropriate offer. So based on the jail incident write-ups pending her coming before you, we have just decided not to make an offer at all. She's entered the plea, but if we need to start over at step 1, we can, but we have not extended the offer, Judge, to allow you to determine what you think is appropriate. So.
Yeah, I think you rejected it off the last time, Judge.
I did, so that's done. We were just set for a status hearing today to see if there was another offer, or an agreement, and there's not. Is that correct?
There's not, Judge, and I spoke with Ms. Smith yesterday, and she's telling me that her family is trying to hire a private attorney, and she would like time to do that.
And in the interim period, Judge, based on those write-ups, the criminal history and the nature of the offense, it's important to take a look at one and make sure it's sufficient. Obviously, she's remained in custody, but we think that is the appropriate place for her to be at the time being.
You have something to say, ma'am?
Yeah, I do.
Okay.
My charge that I'm on, it was offered to me as assault on the officer, and they charged me with robbery. I'm not understanding that.
And I'm more than happy to indict it as an assault public servant, also a second degree felony. I think it would be appropriate as either, Judge.
Well, it's the state has the right to charge whatever they think is appropriate once the case is given to them by whatever agency files that case. There are times when cases are filed as one thing, they take a look at it and think that it might be better off filed as something else. That's what they have the right to do. They took it to a grand jury as a robbery, and a grand jury true billed it as a robbery, so that's what you're charged with. What Ms. Malfino just said is probably just as likely could be either based on the facts. That's not for me to determine, but that's what you're charged with is robbery. And that's what they feel like they will take to a jury. And if you're found guilty at that point by a jury, I would think with this history, I guess it kind of depends on some of these dates. I'm really not sure what
We'll try to secure the appropriate final judgments from Louisiana.
so we know what she would be
What the
facing.
notice would be given for punishment range.
Yeah, okay. All right, so a couple things can happen. I can reset your case just for about 30 days if you think you're going to be able to hire, your family can hire an attorney without us doing anything else today. And if you are unable to hire someone or they cannot hire someone between now and that court date, then when you come back, Mr. Rojas is still on your case. And then if we move your case to the trial docket,
Bruce.
well, sorry. If you're unable to hire someone or your family cannot hire someone before the next court date, then obviously you'll still have a court-appointed attorney. And if at that point we need to move your case to the trial docket to let a jury decide what to do, then we'll go through that on that date, okay? So I'm gonna just do a normal reset for about 30 days to see if you can hire an attorney. All right, you can go back with the bailiff.
Is that Marcus?
Yeah. Okay, and what
And
is
that guy's on bond, it's about no contact.
Charles Young?
No.
I've got to pull this over in front of me. No, I don't. I think I can do this. There we go. Give me just a second. All right, you're Charles Young. Answer out loud. And Mr. Young, you can see on the screen, I'm going to try to make it bigger over there. I don't know what I'm doing. Give me a second. I need the motion so I can see both things at the same time. Thank you. Good morning, Mr. Wilkerson.
Good morning, Your Honor.
And so Mr. Young is, these are so hard to figure out. Charged with burglary of the habitation and cause number 25 DCCR 0102. The state has filed a motion to increase or modify bond conditions. The bond is currently set at $25,000. And Ms. Malfino, you may proceed.
Thank you, Judge. I have not been able to speak with Mr. Wilkerson about this other than on email. I know he included the court on several, difficult to let the case on email, and I don't want to do that. Why I filed the motion was because the complainant in this case, Ms. Harris, has reached out multiple times to the office and sent copies of text messages that either she or her mother or someone she's associated with purport have come from the defendant stating that he will press charges on her as soon as the case is dismissed, that he didn't do anything. Obviously, that's what a jury trial is for, and we're having to go in that direction if we need to. I just wanted to bring it to the court's attention so that he may be admonished, whether he's doing it or not, that he is to have no contact with the complainant, Michaela Harris, either in person, indirectly, through a third party, etc., as a condition of this bond, just because she has reached out and expressed her concern over that.
Your Honor,
So- Yeah.
so I haven't seen any of these messages that Ms. Malfino is talking about. I have provided some of our evidence to her. What I will say is I know that Mr. Young, when he first bonded out, was not aware of who the complaining witness was. Again, I haven't seen any of these messages. I do know that after he met with me for the first time, he has had no contact. If the court were to seek to increase the bond or revoke the bond, I would ask, Your Honor, that the state be required to present evidence of the allegations that are being made.
Thank you, Mr. Wilkerson. And so because she's not here to testify today, I'm not inclined to revoke or raise the bond. But here's what I'm going to do, Mr. Young. Her name is.
And that wasn't necessarily my position,
Right.
Judge, and it's hard for me to share that evidence with Mr. Wilkerson over the Zoom.
Sure. No, you can't do that. We're not going to, and I'm not going to read them out loud. because they're not nice. And if this stuff is coming from you, if it ever came from you, or if it came from someone that you know that was trying to be funny and made it look like it was from you, you're the one that's going to end up in jail waiting on your trial. Do you understand? So you are, as a condition of your bond, to have absolutely no contact with Michaela Harris. You know Michaela Harris, right? Okay. And so here's what that means. It doesn't just mean in person like we are right now. It means any contact, any communication through any way. That's sending DMs or Snapchats or text messages or emails, sending information or messages through other people. Anything at all, if it comes from you, is going to end up you right back in here with the motion to raise your bond. I'll end up raising your bond if I find that you did those things, and you're going to go to jail. Do you understand? So it's very important. Even if she contacts you, let's say she reaches out to you and says, it's okay, let's talk, or let's meet, let's do whatever. If you do it, you're going to jail, not her. She can't give you permission to violate this order that I'm giving you today. So it's only me. And so and as long as you understand that, you need to get with Mr. Wilkerson for the next court date. Y'all can go over everything. He'll get all that information from Ms. Malfino, and then we'll see if we can get an announcement at that next court date. All right, so again, anything at all, if Ms. Malfino gets a phone call that says, hey, this is happening again, I'm getting some messages, then we're going to be right back in here, and it won't go like this, okay? All right. Thank you, Mr. Wilkerson. You're free to go. Mr. Kimler, you have Christy Capel. Have we seen Langston?
We reset it. Remember, he passed on his hearing. Sorry, I forgot to mark it up.
You did tell me that. Good morning. Good morning, ma'am. You're Christy Capel? Yes, ma'am. And Miss Capel, in cause number 24 DCCR 1037 and 2240550, is on probation. And there's MTRPs filed. What is the announcement?
Just gonna enter pleas and true, Your Honor. There's no agreement, and we were gonna ask, I have a question I was gonna put to the court about the restitution of the case.
Okay.
Heavy sentencing.
What is
You have
that?
a PSI come back in November, because it says previously a bond forfeiture, she must have pled and then had a bond forfeiture.
I think I've got a copy of the PSI in my file as well, Judge.
So, okay, let's go back then. It looks like Miss Capel was in court. Sometime back in November of 24 or October of 24. The case was set for sentencing January of 25, and there was a bond forfeiture. Ms. Capel didn't show up for that sentencing. So I guess the question is, are y'all ready to go forward on sentencing based on this pre-sentence
The
report?
state's ready to proceed.
Your Honor, if I may, I believe in consulting with the probation officer, there's $2,446 in outstanding restitution. I'm sorry, 26.
2,426.
26, not 26. The defendant is, could possibly, with
Are you
difficulty,
making,
with difficulty
hold on,
could come up with that rest.
hold on.
Okay.
Are you making an argument on what you want me to do right now?
Well, she hasn't paid the restitution up front yet. My question to the court is to be direct, as if she were to do that, would that affect the court's sentencing decision if upfront restitution was paid in full? Because I don't want to tell, pay the restitution in full and it doesn't have any impact, because Mr. Coleman.
But we're here for sentencing today, so I feel like it's too late for that.
Well, she could, if I could reset it to Monday, if we could pay it, possibly pay it.
I
this
think
week, if
there's
that's gonna
still, well,
impact.
we still have to talk about failure to report, failure to
Right.
submit to alcohol drug testing, failure to comply with JCDI and her drug patch, and the fact that she didn't show up for her sentencing and So.
Correct, Your Honor. And I understand all of that. She's already pled true, I'm sure, to all of that. But would it affect the court's sentencing decision if the restitution were paid, is my question.
I
Because
would,
with Mrs.
I would
Coleman, it
think
doesn't
common
appear
sense
that-
would tell you that anything you can do that you're supposed to
Okay.
do while you're on probation would probably help. I don't know that that's gonna help you stay on probation, but help in some way potentially, yeah, I mean,
Okay.
that's,
Can we reset it for Monday for sentencing then, to give, they don't get paid this week,
that'll be Tuesday.
or Tuesday? Then we can proceed with sentencing Tuesday.
Yeah, and I'm gonna want information on where she's been, what she's been doing since she didn't show up and when we got her in custody. I don't know, if you can visit with her here and just kind of do a little update for me, that would be great. All right, we'll reset it for 1 week. I need to look at this one too, because I guess because she didn't show up, I don't have any notes on it. It's almost like I didn't,
Because it wasn't set for sentencing. I
Oh.
never just set this for sentencing, because I
think-
don't know if you're gonna
Okay.
accept it or not.
gotcha. I'm loading up next Tuesday, aren't I?
Yes, that's okay. Bruce Smith, I think is all we have, and then I have one other thing that Ashley just told me to add on, but I need to talk to you.
Mr. Smith on Calvin Randall.
Oh, I know. Well,
Calvin Randall, Mr. Smith, and Mr. Philip Smith as well. So you're asking,
What is asking if the court will reduce the bond? What's really going on, Judge, is that you got a hearing on a motion to revoke in July the 2nd. He's asking the court to reduce the bond so that he could possibly spend some time with his family before July 2nd in the event you do revoke his probation.
all right, you're Calvin Randall. And so Mr. Randall has 3 new cases. Cause number 24 DCCR 1278, charged with aggravated assault with a deadly weapon. Cause number 24 DCCR 1529, charged with unlawful carrying a weapon on alcohol premises. And cause number 24 DCCR 1530, charged with evading arrest or detention with the use of a vehicle. Then we have cause number 21-36882. Mr. Randall is on probation currently for aggravated assault causing serious bodily injury. There is a motion to revoke probation in that case. There was a request previously for me to set a bond, which I did back in June of 2024. There was a bond set in that motion to revoke case, it looks like. That obviously hasn't been made. There are bonds in all of the others, a $15,000 bond, a $100,000 bond, and a $200,000 bond. And we have gone through, if I'm correct now, what y'all are saying, there were pleas on the motion to revoke, and that is set for a hearing July 2nd.
Yeah, he pled true to some of the administrative counts.
But we're set for an actual hearing with regard
Approve of the
to,
new offenses, Judge.
okay. And you're asking me to reduce the bond on those cases?
Yeah, he's got a total of like $325,000 worth of bonds on, the biggest bond is the motion to revoke bond, which is a $200,000 bond. He's requesting that, I mean, he lives here locally, he's willing to wear any kind of GPS device, whatever, his main motivation is that he would like to spend some time with his family prior to coming back to court on July the 2nd in the event the court does revoke his probation.
Mr. Philip Smith?
State's obviously opposed, Judge. There are some jail incident reports from May 5th. There are also others that go back to February, and then some from June of last year as well.
Well, the incidents on May the 5th deal with, they requested that his blood sugar was above 300, and they requested that he do insulin, and he says, no, I'd like to try to get it down myself. Well, they made that to be an incident.
I'm not worried
Well,
about
it was
that.
also disrespectful and encouraging our inmates to be disrespectful. He wants the
Yeah, there's another incident from that same
Two
day.
from that same day.
Hold on just a second. I'm taking judicial notice of the court's file in each of the cases, just to get myself kind of caught up to speed again, reviewing the probable cause affidavit that has to do with those new cases. Okay,
Two of the cases, the misdemeanors were refused by I believe, unless I'm misspeaking.
I don't know what misdemeanors you're talking about. I mean, we've got an evading arrest with a vehicle, we've got unlawful carrying alcohol, a weapon on alcohol premises, and a new aggravated assault with a deadly weapon, all new cases that have been indicted.
Yeah,
It looks like there was probably, based on the probable cause, I'm guessing there was an evading on foot, potentially, just a regular evading, because that's what one of the allegations.
For example, the weapon on the alcohol is not going to be, as a matter of law, it's not going to be viable because the premises that he was alleged to have been on does not serve alcohol. And the statute's been amended that for him to be guilty of that offense, it has to be a premise in which they serve alcohol and those premises do not. And
The S&S grocery doesn't sell alcohol? The S&S grocery on Concord doesn't sell alcohol?
It sells alcohol, it does not, you cannot consume alcohol. And the statute's been amended to say you have to, it has to be a premise where they consume alcohol.
Okay, I haven't read that, but that's fine. We still have the aggravated assault with a deadly weapon and the evading arrest with a
That's correct.
vehicle,
That is
regardless. Okay, and we're set July 2nd.
That is correct.
No, your motion's denied in all of the cases, I think, based on the nature of the underlying offense that Mr. Randall is on probation for, and the fact that the allegation is a similar allegation, another aggravated assault with a deadly weapon, the evading, all of those underlying facts. I'm going to deny the motion to reduce bond in all of those cases. And we'll see y'all back on July 2nd for that hearing.
Yes, sir.